My name is Emily Chatterjee, and on behalf of the American Constitution Society, I want to welcome you to this press briefing on Caperton versus Massey Coal Company, which will be argued in front of the Supreme Court next Tuesday, March 3rd. For anyone who is not familiar with ACS, we are a national organization of lawyers, legal scholars, law students, and policymakers who are working to advance a progressive vision of the Constitution, law, and public policy. Our mission is to ensure that fundamental principles of human dignity, individual rights and liberties, genuine equality, and access to justice enjoy their rightful central place in American law. Today's press briefing will focus on the Caperton case, which raises important questions about judicial elections, due process, and the integrity of state courts. We have an outstanding panel with us today to discuss the case and the arguments that will be presented before the court. Before I introduce our moderator for today's panel, I would like to remind the audience that the event is being recorded and to please turn off all cell phones. We will have time for questions at the end of the briefing, and there will be someone with a microphone going around. Please give your name and affiliation before you state your question. We will be taking questions from members of the press first. Now, I'm pleased to introduce our moderator for today's panel, Professor Charles Jay. Professor Jay is the John F. Kimberling Chair in Law at the Indiana University School of Law in Bloomington, and we are delighted to have him with us today. His work on judicial independence, accountability, administration, and ethics has appeared in over 40 books, articles, book chapters, and reports. In addition, he is currently the director of the ABA Judicial Disqualification Project and has previously served as reporter to 4 ABA commissions dealing with various aspects of the judiciary. Professor Jay's full bio is available on our bio sheet at the sign-in table, along with the bios of our other panelists. We are very pleased to have his expertise and expertise of our other panelists and want to thank our panelists for joining us today. Professor Jay?
Greetings, folks. I want to begin by telling you stuff that you probably already know. I am, after all, an academic, but I'm going to do it in as learned a manner as possible. What I want to do is essentially make sure that we're all working from a level playing field here when it comes to the facts underlying the Caperton case, so that folks know where we are here. In 1998, Caperton and others filed suit against the Massey Coal Company for fraud and tortious interference with plaintiff's business in connection with the negotiated sale of a coal mine. 4 years later, the jury finds for the plaintiffs, for Caperton, and awards more than $50 million in damages. Post-trial motions filed by Massey, keep the case in the trial court for several years. During that time, while the case is pending, the Massey CEO, Don Blankenship, spent over $3 million on behalf of attorney Brent Benjamin in support of Benjamin's successful 2004 campaign to defeat incumbent Justice Warren McGraw on the West Virginia Supreme Court. And I think it's important also to recognize that that $3 million was not direct to his campaign. It was spent on his on behalf of Justice Benjamin, and that money represents roughly 60% of the total support that Justice Benjamin received. In 2006, with the appeal to the Supreme Court imminent after post-trial motions have been exhausted at the trial level, an appeal is imminent coming from Massey, the petitioners, Caperton, are looking to Justice Benjamin and asking him to disqualify himself. Now, as in virtually all states, West Virginia has a disqualification rule that says that a judge must disqualify him or herself whenever his impartiality might reasonably be questioned. And Justice Benjamin determined that he was not required to disqualify himself in that case and did not. He then and I think in West Virginia, as in many jurisdictions, there is no process for appealing Justice Benjamin's decision not to disqualify himself. And so that was that, essentially. The case then goes to the Supreme Court, where on a 3-2 vote, the judgment in favor of the plaintiffs is reversed. Judgment is entered in Massey's favor. The matter is subsequently reheard for details that are, pretty interesting, but I'm not going to digress. We can talk about that a little later. On rehearing, Justice Benjamin is asked to recuse himself again. Again, he declines to recuse himself. And another 3-2 decision with Justice Benjamin again in the majority. Now, in working through this, I think that the issue is ultimately fairly narrow that's coming before the Supreme Court. And we're really just asking whether a justice who fails to disqualify himself under what I'd characterize as this perfect storm of circumstances, deprives a party, here we're talking about Caperton, of his rights to due process of laws guaranteed by the 14th Amendment. And I think it's just important, before I introduce the speakers and then shut up, that we be clear that we're not simply talking about whether a justice needs to disqualify himself every time he receives campaign contributions from a party. That we are talking here about a circumstance in which the case in which the party has appeared. Not just previously appeared, but the amount of that contribution, the amount of the contribution involved is very high, $3 million, where it is a high percentage of the overall support that the judge has received, where the timing of the contribution occurs, or the timing of the support occurs while the case is pending, where there is no process in place to review the decision of the individual judge, and where, as far as the outcome is concerned, there's no room to argue for harmless error because you have a 3-2 decision in which the judge that you're worried about is in the three-member majority, and the issue really boils down to whether these circumstances give rise to a due process problem. To address this question, we've got 4 terrific folks that I'm delighted to introduce. The first is Bert Brandenburg, who is the executive director of the Justice at Stake campaign, which is a national nonpartisan organization devoted to promoting fair and impartial courts. He previously served as the Justice Department's Director of Public Affairs, and before that held a number of policy positions with government and private organizations. He received his law degree from the University of Virginia, and I will say I'm on the board of directors at Justice at Stake in a spirit of full disclosure. Amanda Frost is, will speak next. She is an associate professor at American University's Washington College of Law, where she teaches civil procedure and federal courts. She previously practiced with the Public Citizen Litigation Group, and before that clerked for the Honorable Raymond Randolph on the D.C. Circuit. She's written about the relationship between federal and state courts and about judicial ethics, and has written a piece that I think is terrific called "Keeping Up Appearances: A Process-Oriented Approach to Judicial Recusals" that appears in the Kansas Law Review. She graduated from the Harvard Law School. Next to her is the Honorable Richard Neely, whose resume reads like his own, like a who's who of himself. I mean, it's a remarkable career that he's had. He is a former justice and chief justice on the West Virginia Supreme Court of Appeals, where he served from 1973 to 1995. After retiring from the court, he returned to private practice in West Virginia. He previously served on the West Virginia legislature. He has been a professor of economics at the University of Charleston, and while a justice, he was a prolific writer, writing for many national publications and authoring a book that is both insightful and extraordinarily interesting, How Courts Govern America. He received his law degree from the Yale Law School. And last, and certainly not least, is Justice Harold C., who was a former associate justice on the Alabama Supreme Court, whose career is likewise absolutely extraordinary. He served on the court from 1996 to 2009. He previously served on the faculty of the University of Alabama Law School, where he was a chaired professor. Before that, he was an assistant professor of economics at Illinois State University and practiced law with the Chicago firm of Sidley and Austin. Justice C. received his law degree from the University of Iowa, and it is safe to say that he has been through the judicial election wars and emerged intact. I will now sit down and subside and turn the podium over to Bert. Thank you.
Thank you, Charlie, and good afternoon. It's an honor to be part of this panel, and I'm virtually the only one here who's not tenured or been elected by the voters. Protocol would normally put me, therefore, anywhere but first to speak, more likely somewhere after the caterers and the cleaning crew. I promise not to abuse my leadoff spot here, and the reason I was asked to go first was that my job today is to give the national backdrop against which this case is playing out. What I hope to show is that while the fact pattern in Caperton sounds extreme on its face, and I think by any normal standard it is very extreme, it is in fact a very logical and a very predictable result of what has been happening to judicial elections in the last decade. And given what's been happening, you may be appalled, but there really is no excuse to be surprised if you've been watching. 3 quick disclosures. As Charlie J. mentioned, he is on my board of directors, which means that I've been used to evading his questions for a while, and I plan to do my best here today in the follow-up discussion. I'll mention as well, Justice at Stake has filed an amicus brief in this case supporting the petitioner. And finally, I'll just mention as well, the Justice at Stake, which is a nonpartisan partnership of more than 50 organizations, holds within its collective body a diversity of opinions on the best way to select judges. We don't endorse any one particular system. We have lots of lively discussions about that. And Caperton's not about that, but that is in the backdrop. What Caperton is about is whether the Due Process Clause will be available to help ensure litigants a fair day in court in the face of the trends that I'm about to describe. State courts, of course, are the workhorses of American justice. They deal with something like 98% of litigation. Nearly 90% of our state judges must stand for election of some type, either contested races of the type we're all used to, or retention races where, after having been appointed, you stand by yourself to essentially be kept or fired by the voters. And in the last decade, mostly in these contested races, a new politics of judicial elections has emerged. It's been a growing tide of partisan and special interest pressures, and the design is to pressure judicial candidates into being accountable to campaign trail politics rather than the law and the Constitution. And the pressure comes from several sources, and it's worth taking a minute to note them. They're not all at issue in Caperton, but they're all deeply intertwined with the issues that are going to be debated next week at the court. And the first is the one that we are talking about today, is money. Since 1999, Supreme Court candidates have raised collectively over $168 million to run for their offices. 15 states have smashed their fundraising records. In Illinois in 2004, the two candidates running in a remote rural district, Illinois districts its Supreme Court by geography, the two candidates together raised $9.3 million. That was more than 18 out of 34 U.S. Senate races that year. The winner, this is the winner on election night, Justice Carmeier said, "That's obscene. How can people have faith in the system?" Not your usual winner's speech. Where does this money come from? An enormous amount of it is raised from litigants who then appear before these judges. And why? I'll give you two words: tort wars. Plaintiffs' attorneys and labor unions are duking it out against businesses and commercial groups in a classic arms race. The second element of pressure on judges that we see rising is TV ads. And in fact, much of the money that we're describing as being raised goes into getting candidates on the air, and an enormous amount of independent expenditure money also goes into separate TV ads. And these ads frequently target opposing judges for any case where a criminal defendant wasn't put away for life. Any judge who's had any kind of career can usually be defined through one case as the weakest judge you've ever heard of, and unwilling to give a full prosecution to anybody. I would add as well that they are often misleading. This is, of course, a rich tradition of politics, but it's worth noting the consequences in the legal context. In Michigan this past year, the Chief Justice of the Michigan Supreme Court, who has served for 8 years, may well have been run off the bench. He lost his race by an accusation in an ad that really had a lot of cut-through value, that he fell asleep while hearing a case. And the best I can say is there are a lot of indications the allegation may have been a lie. It may not have been true, and he may have just been run out of town because of that ad, because of that accusation that appeared in the ad. The third element of pressure that we see increasing on judicial candidates is questionnaires. We've seen a rise in questionnaires on hot-button issues like abortion, same-sex marriage, death penalty. And the goal of the groups explicitly is to increase pressure on judges. They want check-the-box justice. Take a complicated legal issue, make you check yes or no, and this will determine whether a lot of PAC money and voter turnout is organized for or against you. And I would finally mention as a related factor that in judicial elections, voter turnout typically is rather low. So these are voter vacuums waiting for interest groups to come in, turn out their base, and tip the race. And they're easily swayed by pressure and partisanship. And I will just mention as well that we saw on a party line basis 22 experienced Republican judges swept out of office in Harris County just this past fall simply because they had an R on their name in a D year in Harris County, which is where Houston is. And similarly, 2 years before, in Dallas County, 26 Republican justices were swept out of office, again, not based on their experience or actual issues, but simply because they were not Ds, and the Ds were up that year. The accumulation of these trends, I think, show that the Caperton case may shock the conscience, but this was bound to happen. And if not in West Virginia, then somewhere else. Judicial elections are becoming a Wild West. And as big money becomes the new normal, it just won't be that surprising if a new generation of judges comes of age feeling much more comfortable with the river of interest group money swirling around them and pouring into our courts of law. I would add as well that Americans feel less sanguine about this situation. 76% of Americans believe that these campaign contributions do influence judges' decisions. 79% of business leaders agree with this same statement, And I would just note that in the Caperton case, the amicus briefs included a business brief on the behalf of the petitioner, signed by household names like Walmart, Pepsi, Intel, and Lockheed Martin, all very concerned about what would happen if the Supreme Court does not invoke the due process clause in this case. I would also mention that half of state judges agree that campaign cash is affecting courtroom decisions in a poll conducted by the National Center for State Court. As a result, there's been growing interest in a number of reforms, including disqualification and recusal, and we can get more into this in the discussion, but I at least want to mention that the American Bar Association, in large part through the work of Professor Jay, and the Brennan Center have both done work on reforms in this area, and I would commend you to their work. I hope that every court, regardless of how Caperton turns out, that elects judges will take a fresh look at their recusal provisions. The ABA Model Code does indeed include a trigger provision that a certain amount of campaign cash should at some point trigger recusal. In the state of Wisconsin, a petition has been filed to actually have the court adopt such a rule, but the fact of the matter is that this has not been a rule that's been particularly well adopted by states. I would mention as well that the Conference of Chief Justices and 27 retired justices also agreed that there's a constitutional problem, and they have told the Supreme Court that new recusal rules are needed for election scenarios. And in the end, however, the tough part here is that courts actually have to approve these changes. Recusal and disqualification is typically a court-made rule, and human nature and political experience show that all branches of government are usually not speedy in policing themselves. And I would just add here, as I get ready to close, that once again Americans are ahead of their leaders in this regard. We actually just released a poll this week, and we have a copy of it that I think is either being distributed or that you can get, along with some reporting on the money, that shows that it's by Harris Interactive, and it shows that 85% of Americans want judges to step aside from cases that involve a party who spent significant money to get the judge elected. And in addition, 81% of Americans say that judges should not be the ones deciding whether they themselves can fairly hear a case, and they say that another judge should weigh the facts when a judge's neutrality is challenged. Only 11% of people disagree with that statement. In other words, Americans believe that the status quo as it is now unfolding is unacceptable. And I'll just close by saying that in addition to the constitutional implications, the outcome of Caperton is also going to send ripples, no matter how it turns out, through the culture of judging for years to come. And my fear is that an adverse decision would invite special interests to ratchet up their arms race even more and encourage more judges not to worry about the cash piling up in their courtrooms. On the other hand, a positive decision, in addition to the merits, would send a strong signal the current system needs to be fixed so that every American can be confident that they'll get a fair day in a court that is impartial. Thank you.
So I'm going to discuss the due process standard that is at the heart of the legal claim before the court. As I think you've already learned from Professor Jay, there are statutes in every state that require judges to recuse. They use different standards, usually along the line of whether a judge's impartiality could reasonably be questioned. And there's also a federal statute. But those statutory standards are not at issue here. A state decides for itself whether its statute has been complied with or not, and that's not a matter for the U.S. Supreme Court. Here the court's being asked to determine whether the due process clause of the U.S. Constitution was violated by the fact that Justice Brent Benjamin did not recuse himself. And the question for the court is, what does due process require in a case like this? What kind of campaign contribution or other influence on a judge's campaigning an election could require that judge to step aside in a subsequent case? So there's been three possible standards bandied about in the briefs. I thought I'd mention each one. First is the possibility that you'd have to show the judge was actually biased. And if you could show that, due process would require the judge to step aside, but something short of that would not require the judge to recuse. And as the petitioner states, that would be a nearly impossible standard for anyone to meet because, of course, judges rarely say, I am biased, as they sit on a case and refuse to recuse themselves. And it would be quite difficult to get evidence of actual bias in any specific case. So the petitioners reject that as the standard. Another possible standard would be appearance of bias. That is the fact that there's a strong public perception that the judge could not be impartial and could hear the case impartially. whether or not the judge is capable of sitting and hearing the case and judging it impartially. If there were a strong appearance, there's been an argument that the judge should step aside. That is also not the standard the petitioner is claiming. There's some dispute about whether the petition itself was written based on an appearance claim, an appearance standard, and whether the petitioner has now changed its position and is arguing instead for this different probability of bias standard. I don't think the issue is one that's going to inspire the court to dismiss the case as improvidently granted, as respondents asked. So I don't think it's going to end up being an issue, that the petition was framed a little bit differently than the petitioner's brief. In the brief, the petitioners argue for a probability of bias standard. They say when you either can show actual bias or a probability of bias, the judge involved should step aside. They very clearly and specifically do not give a bright line test. They don't try to say in all cases in which campaign contributions are over 50% of the total raised, for example, the judge should step aside, or in all cases in which a campaign contribution was given while a case was on appeal, the judge should step aside. They very clearly do not say that. They instead say that due process is a flexible and contextual standard, and that in this case, with all of the factors we have present here, the probability of bias standard is met. And those factors are the fact that the contribution by Don Blankenship was made, the campaign involvement of Don Blankenship and the $3 million that he contributed both as an individual to the justice, that was only an $1,000 amount according to West Virginia limits on campaign contributions, then the $3 million he gave for a foundation that ended up lobbying in Justice Benjamin's favor, campaigning in Justice Benjamin's favor. Those contributions came in the course of the appeal of the Caperton case up to the West Virginia Supreme Court, and they were a very large percentage of the total that was spent on Brent Benjamin's campaign, 60%, and they combined with the fact that this case was on appeal at that point in time, and it was one in which obviously Don Blankenship had a great deal of interest as CEO of the Massey Company. Those factors combined say the petitioners to require that he recuse himself. Respondents respond that you need a more specific standard and that without a bright line rule, you are creating a very messy situation in which it'll be unclear that even elected judges can continue to sit on cases if every time they receive a campaign contribution, there's a risk that they're going to be found to have violated due process to sit on a subsequent case involving the contributor. So that, I think, is the due process issue in a nutshell. An issue that the court will not address, almost certainly, is the fact that Justice Benjamin was the sole decision maker as to whether or not he should step aside. The request that he step aside, the motion that he recuse himself, was decided by him and him alone. We know that other justices on the court were very disturbed by his refusal to do it. And that is not an issue the court will address, I'm guessing in large part because the Supreme Court justices, the U.S. Supreme Court justices, themselves decide for themselves whether they will step aside when asked to recuse themselves, and for probably very good reasons, the petitioner is not making an issue of that. And while I hope we have more discussion in the question and answer phase of this proceeding, I just want to note that I think that is one of the key problems, that whatever standard one picks, whether it be a statutory standard or the probability of bias or actual bias or appearance of bias standard, I think that standard is going to be difficult to have met if the very judge who is supposed to decide whether to recuse himself is the one who applies that standard to his own conduct.
When I was a young lawyer, about noontime, I found myself in Belington, West Virginia, and I parked my car, and there, lo and behold, felicitously was standing a constable. And I went up to him and I said, "Constable," I said, "what's the best restaurant to eat in this town?" And he said, there are two. There's Jaegers and there's Howlers, and you go to either one of them. And I said, well, if you were going to go have lunch, which one would you go to? He said, I go to both of them. He said, you go to one of them or the other one. He said, I go to them all about equally. And I said, so you don't have a choice? He said, no. He said, I don't have a choice. But I can tell you one thing, son. Whichever one you go to, you wish to hell you'd gone to the other one. And that's sort of the problem that we have in judge selection. Just as George W. Bush is the 21st century's leading argument against hereditary monarchy, the federal court system is America's leading argument against lifetime appointed judges. So. And we have, of course, the Caperton case, which is like Jaeger or Howler's, a leading argument against a type of responsive elected judiciary. I'm much more interested in a technical aspect of the implications of this case. And you'll find that Justice C and I are not all that far apart, although we've been brought to be either the hammer or the anvil, and I haven't figured out which one I am on this question of whether the Supreme Court should decide to reverse this case. What I'm worried about is a rule that creates ancillary litigation. Litigation is extraordinarily complicated and extraordinarily expensive. And for all of you who are out there in think tank land or press land and who are not down groveling in the dirt, trying to get some coal miner his benefits who got his leg cut off, in a Massey mine, or who isn't struggling to try and keep, credit card companies from raping consumers, you don't understand that it's like a war. An army runs on its stomach. If you don't have ammunition and you don't have food and you don't have good warm clothing, your army falls apart. And that's the way it is in litigation. In the real world, litigation costs money, and if the Supreme Court goes and creates big-time rules that are going to invite some kind of ancillary proceeding every time a case goes in front of elected judges, you talk about elected judges and campaign contributions. It's like some guy who goes out and builds himself a first-class whorehouse. By God, he puts in red velvet drapes. He gets round beds, with mirrors up on the ceiling. He has a fine Steinway piano down by the bar, and he's got it in a sweet, quiet neighborhood. And he leaves, and he comes back in 5 years, and he's shocked to find that there are whores living there. Well, this is the basic problem with an elected judiciary. That what the hell did you expect? To say that it's politicized. Now, believe it or not, those of us who are sort of professional whores, you see the difference. I'll tell you the difference between politicians, between elected politicians like senators and congressmen, and judges like me, is that with senators and congressmen, you take a lot of real young, idealistic, hard-charging, public service-oriented guys, send them to Washington, and within 5 years you turn them into whores. With judges, you take good old, tired, experienced political whores, and in 5 years you turn them into virgins, you see. At least that's the idea. And this actually was what we tried to do in the Code of Judicial Responsibility. If you look at the West Virginia Code of Judicial Responsibility, what we used to call the Canons of Ethics, or Code of Judicial Conduct it's called now. They changed the names to protect the innocent. There are a whole lot of restraints on what judges can and can't do in an elected campaign, and the Supreme Court of the United States ruined that system in Republican Party versus White. When the Supreme Court of the United States said it is unconstitutional to deny a judge the right to say, well, I'm going to convict all the criminals. I'm going to send them all to jail. And by God, not only am I going to convict the guilty, I'm going to get some innocent ones too, just to make sure that we don't miss anybody. Now, as soon as you can say that and can run a campaign based on it, you have ruined the whole delicate system that was set up. Because in West Virginia, we never had this problem. We had reasonable campaign contributions. You all know that Francis Bacon, the great Francis Bacon, was Lord Chancellor to Charles II. And he was Lord Chancellor. Anyway, he was impeached as Lord Chancellor. And his defense on being impeached was that he took campaign contributions, or took bribes rather, from both sides evenly. Although he was impeached for bribery, his defense was that he was bribed evenly. And this is what we more or less used to have, that you would have lawyers make $1,000 contributions. In West Virginia, the limit, these Massey expenditures were 527 expenditures. Massey doing his own advertising. We would have $1,000 contributions. Lawyers would contribute $2,000, a check from them, a check from their wife. You know, if they were really enthusiastic, they'd get their two adult children to make it. But it was a reasonable amount of money, and it was done by both plaintiffs' lawyers and defense lawyers. Criminal lawyers on either side didn't have any dog in that fight. And so it worked perfectly well. Now, my point about all of this is that we do not want the Supreme Court of the United States to do anything but pop this case. And and say, this is too much. You know, it's like pornography. We can't define it, but we know it when we see it. And I think the due process thing, just to go to Amanda's, where do we find the rule? It's really simple. Due process arises out of the common law and common law tradition. One of the preeminent rules of the common law, so preeminent that you still say it in Latin, is nemo debet esse judex in propria causa. No man should be judged in his own cause. And therefore, if you have any financial interest in a case, you are prima facie disqualified. It is not a great leap to say that when somebody gives you $3 million, you have a serious relationship with that guy. And you may need money in the next election. Therefore, that is a substantial relationship. Now, there is another rule, and it's called the rule of necessity. And the rule of necessity is that if you are the only judge who can decide a case, then you have to decide it. That's why the entire West Virginia Supreme Court sits on public utility rate regulation cases, in spite of the fact that we are all public utility rate payers. I say we, they. So it is not a great leap to say it is necessary in an elected judiciary to have campaign contributions. Therefore, as long as those campaign contributions are more or less within the norm and do not exceed the spirit of the campaign limitation statutes of the state, that's fine. That when you Therefore, and this would be how I would conclude the opinion if I were on the Supreme Court, there has been a due process violation in this case, and the rule is when you see an owl at a mouse picnic, you know he didn't come for the sack races.
If we're going to take seriously the idea of case or controversy, then it seems to me it matters a little what the facts are in this case. Otherwise, the Supreme Court may be deciding some general principle out of the context of a particular case. I've heard, and there's some things that are both in the briefs and in the presentations that presume certain things about the facts that I think I'd want to think a little more about. For example, this $3 million figure, as was pointed out, the $3 million was given to a 527, not to Benjamin, the candidate. was given to him by someone who was not a party to the litigation, although he's an officer in a party to the litigation. Let me say a word about the 527 and about Blankenship. The evidence that I pick up from the briefs is that, in fact, it was Blankenship's intention to get rid of McGraw. There's no indication that he ever met Benjamin. And he had talked about trying to get rid of get rid of McGraw evidently before Benjamin was in the race. The money was given. The $3 million. Yeah, he gave $1,000, but the $3 million was divided between some independent expenditures that he made, all not for Benjamin but against McGraw. The $2.5 million that he gave to the ASK, to the PAC, was also money that he gave to have a campaign run against McGraw. Now, I think that's significant. I'll try to come back in a little while to why I think that is significant. But I think it's a significant difference in the facts from saying that that Blankenship gave $3 million to Benjamin or to Benjamin's campaign. He simply didn't do it. Also, before this case ever got to the West Virginia Supreme Court, Benjamin had ruled against Massey in 4 different cases. And one of them, as I understand, substantially larger than this case. When the case was tried, or what came to the Supreme Court the first time, there was a 3-2 decision in favor of Massey. Benjamin was one of the 3. By the time it came back, 2 of the Supreme Court justices agreed that they needed to recuse for other reasons. And so Benjamin, then sitting as acting Chief Justice, picked 2 other judges to sit on the court to decide the case, one of whom voted with him in the majority, one of whom voted against him in dissent. These are not strong indications that that Benjamin is somehow working to repay some debt. I suppose that's I'm not going to try to address everything because I'd much prefer taking the questions and we'll have a chance to address the issues you care about. Oops, I got to flip one more page here. Well, I guess I have to flip 2 more pages. I took more notes than I thought. Old habits. Now, I had a note that I wanted to address from Professor Frost. There we go, yeah. As she mentions, this is presumably not an actual bias case. It wasn't. It at least wasn't presented that way in the original petition. It was presented as an appearance case, but in any event, the discussion seems to be revolving around a probability of bias or something like that. It's a little hard, though, to know what that is. The language about probability of bias is focused on these questions of, well, would you feel some debt of gratitude, or at least that seems to be the language that crops up most often. Do you feel some debt of gratitude for what they have done? Well, here, first of all, I think it matters where that money was given, whether it was given to Benjamin or given to an independent 527, which is simply interested in defeating someone who's in office. For a couple of reasons, I think it makes a difference. One is, if you've ever run for office, you're really uncomfortable with those outfits because they hurt you as often as they help you. Right? They go off and argue what they're interested in as opposed to what your campaign is all about. But there's another reason. If we're serious about this idea of a debt of gratitude, and you have someone who is out to get someone out of office, whatever the office is. That goes more, doesn't it, to whether you did a good job picking your opponent. That's one of the keys in politics, picking your opponent and knowing when to pick him. So the question is, are you really going to feel a debt of gratitude? I think of it a little bit like you knock your ball into the water, and you'd like to go get it, and you look and you see the alligators on the other side of the pond, and you step in and get it. You don't feel a debt of gratitude to that alligator. I mean, you're glad he's over you. You're glad he made that choice. I'm glad that, Benjamin might say, I'm glad that Blankenship, that's it. I kept thinking Brandenburg, and I thought, that's not it. He may well have been very grateful that Blankenship chose to spend all that money against McGraw, but that doesn't create a debt of gratitude. But if it does, and if we're serious about this debt of gratitude, then it strikes me that it's next to impossible to stop there. You'll recall there was this money that was spent on where are we here? There was this money that was spent. The $1,000, the $3 million. Well, it appears to me from the numbers I see that Benjamin still had $2 million to run a statewide campaign in West Virginia. It would strike me that that's sufficient, and so this is not one of those things that's critical to him, unless you believe money buys elections. And I've seen too many examples to the contrary. If that were the case, I guess we'd be talking about. Looking at the early time, at the early days, we'd be talking about another President Clinton who was raising all the money until it appeared that Obama was going to win the nomination, which time the money, or had a chance to win the nomination, at which time, through support, through voters and the like, at which time the money started flooding in there. Money frequently follows likelihood of success, not produces it. But oftentimes those with less money win these elections. So at a minimum, we're not talking about 60% debt of gratitude, are we? I mean, there are other things that happened. Virtually every newspaper in the state, all but one of the major newspapers that endorsed Benjamin. Only one went the other way. That's a significant factor, it seems to me. That reduces that debt of gratitude. It may create another one, the newspaper, so maybe he shouldn't sit in any newspaper cases. And what about the grassroots work? It's always, virtually always critically important in an election. So there are all of these factors at work as well. Plus, the discussion is as if Benjamin got the $3 million. What he got was a $121,000 a year job. Right? I mean, there's going to be a debt of gratitude. It's a debt of gratitude for what he got, which is he's on the Supreme Court, which the numbers I saw say $121,000. I don't know if it's more than that or less than that. That we make the appropriate adjustments. But, of course, you don't become a judge for the money, do you? You become a judge because there's something you believe in, because you care about the law. Now, why are we going to presume that someone who had money, that somebody who's in a situation where someone wanted to get somebody else out of office and he ran and he won, that he's going to sell his integrity that cheaply? That just strikes me as a peculiar presumption. The presumption's always been the other way, hasn't it? We presume that a judge is not biased. We presume it. And it takes a significant burden to overcome that. Now, I'll also note that I do believe, as Mr. Brandenburg pointed out, that there's a whole lot involved here about whether judges should be elected or not. But I'd submit to you that's not before the court, and that, in fact, there are good reasons to elect judges. Judges were originally appointed. And lawyers played a major role in changing that to the election of judges because they didn't like the backroom politics of judicial appointment. Well, that backroom politics. I mean, you can make the arguments. You can talk about how you structure it, and I'd be happy to talk about all those. But I think there's a good argument as to why judges ought to be elected. I don't know whether we're talking about the same poll here, but there was an ABA poll that showed 70-some% of the public was troubled in some measure or another about judges getting contributions. But 75% in that same poll said that they believe elected judges are fairer than appointed judges. Remember, we need to compare these things. It's not, do you like the current system or would you prefer a perfect system? The question is, which system is better? Which system works better? If we're going to have this rule, it seems to me, there's no rational basis to apply it only to elected judges. When a judge is appointed, he owes a federal judge. He owes his entire appointment to the president. Should he then recuse from any cases involving the president or the president's office? He presumably has a debt of gratitude to those senators who voted for him. And I don't know why there's a difference between positive and negative. He may owe a debt of resentment to those who voted against him. In which case, we can pretty well cut out all the judges at some level or another. Well, I'll stop at that and let you pursue it with your questions. Thank you.
I wanted to begin by letting individual panel members sort of offer their own thoughts on what others have said on the panel before I ask any specific questions. In other words, that you've heard from each other, and I just wanted to open it up to members of the panel to say what's on your mind in light of what you're hearing from each other.
I guess I'll just jump in and say that I take your point about judges, there should be a presumption of impartiality. Mm-hmm. But I wonder whether that presumption isn't weakening under a system that especially in the last few years, because of Minnesota versus White and because of the changes in the way campaigns are working, has led now to maybe we now cannot trust the way we once could the impartiality of judges. That's what I'm wondering, whether that is what led to the Supreme Court granting cert in this case.
Well, let me drop back just one space and move back to it. There is a change that is going on in judicial selection. I think it's a change, though, that is brought on by those competing groups you discussed. The plaintiffs' bar and the business community, to oversimplify it. And we are seeing that same effect, I think, in appointments that we are in election. I can't remember where I read the figure, and it may be wrong, but my recollection is that I read a newspaper article that said just television advertising alone in the Chief Justice Roberts and the Justice Alito appointments was over $15 million. Now, a whole lot more money than that got spent. And groups were actively involved in trying to defeat or promote that appointment. That same corrosive effect is taking place in all judicial appointments. I would argue because judges have gotten into the lawmaking business a lot more than in the past. And you want to be able to elect, or you want to influence your lawmakers. So we have that going on. I don't know that calls for for essentially abandoning judicial elections, which an aggressive rule of this sort would. Now, a less aggressive rule is just going to cost money and going to hurt clients and making them wait longer to get the case over with. But I think an aggressive rule would essentially devastate judicial elections. So then people would be elected essentially in ignorance. Right? I mean, it costs money to get information out, or in total reliance on the newspapers, in which case I'm not sure I want the newspapers to be the ones influencing my judges. So yeah, maybe, but I guess I'd say so what? We still need to do what we can with the systems that we have. I agree. On our court, an individual justice, after making the recusal decision, that could be essentially appealed, or there could be a motion to have the entire court consider it. I like that. That makes sense to me. There are other things that can be done. I mean, I mentioned some disagreement over the facts. The problem is, this is a highly factual case. Who makes factual decisions? Well, I don't think it ought to be the United States Supreme Court. And certainly legislatures can take steps. We have judicial inquiry commissions that can look into judges who, in fact, are deciding in ways they shouldn't. It seems to me that this is a matter that is much more appropriately resolved at the state level than at the federal level.
If I can just add a comment to your question, I really want to presume that judges are impartial, and I really don't want to think that they're not are impartial. I'm being Blankenship again. I really want to assume they're impartial, and my fear, and a lot of people's fear, is that the way the system is changing under our feet, that presumption is just harder to automatically hold anymore. We want to start there, but the Supreme Court took this case because it got to such a sort of smell test in terms of $3 million pouring into the campaign. And I think one of the interesting things about Massey's argument is that they don't provide any clue that any amount under their argument would ever be enough to cause a judge to recuse under due process. So it could have been $6 million or $60 million or $600 million, and under their argument, there would have been no due process argument. Whether this number is perfect for the decision you want, I don't pretend to know. But if the Supreme Court can't take a look at this and say that at some point enough does have to be enough, even if a standard that comes out is not the easiest thing in the world to follow up on, then I'm not sure what the due process clause is supposed to be there for. And if I can just add, actually, I think you have something on that. I was going to add one other thing, but yeah.
Say, you're making that same presumption that this $3 million is $3 million going to Benjamin and his campaign. I don't think it is, but there are facts we could argue about.
That's actually the next point I want to go ahead and address,
okay,
which is when you made that comparison, I guess what I was thinking was that if we were both farmers and we had farms next to each other, and there was a wolf who was after me, and you didn't even know me, but you shot that wolf just because you hated that wolf too, I would feel no less grateful to you for shooting that wolf. And the issue is not, you talked about the intention of the person spending the money. I don't think that's the issue. The issue is the effect on the recipient of this kind of favor. And I don't think the effect on any justice would be one whit different if the money was spent on their behalf. And I would just add that those 527 ads did say elect Brent Benjamin as well in many of them. And so whether or not he says I was against somebody or for somebody, I don't think that there is a distinction in this case.
I think that I've been very, very attracted to Justice C's argument. But just factually, Massey Coal buys a lot of stuff. Buys mine cable. It buys Walker equipment. It buys Caterpillars. Right? Blankenship knocked down every person Massey did business with for the purpose of raising money to go into this 527. The 527, as a matter of fact, right, was supremely well coordinated with Justice Benjamin's campaign, and Massey saw to it that clean, reportable contributions from all kinds of people that nobody ever heard of, little old ladies in tennis shoes, right, who were the mothers of people who owned, an equipment supplier, right, went to Benjamin himself so that he could put up huge billboards that said, "Who is Brent Benjamin?" Just name recognition to get the campaign off the ground. As a matter of fact, there was far more involvement in this race. And remember, this is an appearance of impropriety. I actually like Brent Benjamin. And he is, notwithstanding having been elected as a Republican, has turned out to be a surpassingly well-balanced, good, intelligent, and quite humane judge. So I have no no bad feelings about that. I can tell you that this was a horrible case, the Massey case. It was an example of real oppression, of absolute thuggery on the part of A.T. Massey. It was lying, cheating, thieving, compelling people into, forcing people into bankruptcy, trying to steal their coal land. The first opinion that came out in this case actually said that this is one of the worst, most egregious sets of facts we have ever seen, but nonetheless we have to reverse it on this technical issue of a forum selection clause. If you read the opinion, I invite you all to read the opinion. It is a truly bad opinion. And for one thing, there are 55 pages of pseudo-scholarship and just basic garbage of cases being recited, et cetera, so that there's a lot more factually to this, and somehow the Supreme Court must have sniffed that out. I mean, I guess they've got 7,000 law clerks for some reason, and they I think must have sniffed out that this is not just an ordinary case. If Benjamin weren't really interested in this case, why wouldn't he have disqualified himself? All somebody had to do was breathe disqualification to me, and I was gone, because I'd much rather be out digging post holes or something. So, I mean, I think that has to be taken into consideration.
You know, one fact I just wanted to quickly add about the 527 that Blankenship's created, I believe it's called "And for the Sake of Kids." I mean, this is not of great interest to the Supreme Court, but Blankenship recently gave an interview to the New York Times where he admitted, very frankly, refreshingly honest, said, "And for the sake of kids," was we set it up to make it sound like Justice McGraw, who was replaced by Benjamin, who lost in part as a result of Blankenship's efforts. We set it up to make Justice McGraw look bad on issues involving children. We found a case where he released someone who was accused of being a pedophile. We publicized that case. And he said, "But that's not why I started this organization. I started it for the sake of kids to get McGraw off the court because I wanted someone who'd protect my corporate interests." That's, I think, the most upsetting thing about this case, because it's happening not just in West Virginia. It's happening in many, many states. People take a hot-button issue, like releasing somebody early from a sentence or some pedophile getting out of jail and a judge supposedly being responsible, and use that as a reason to try to get someone into office who they think will benefit financially.
I think you want to jump in here, but I want you to do so, but partly in reference to a question I had when you were talking, which is, why isn't a decision in favor of petitioners in this case good for judicial elections? In other words, we've got John Grisham out there writing novels about this. We've got the smell of corruption sort of being bandied about in the press. We've got the bad boy in all of this being judicial elections. Is there no end to it? In other words, is there no backstop? After, how bad can it get? And if the answer is as bad as you want it to be, in other words, the due process clause won't step in, well, then the next step is to say, well, it's about time to start thinking about judicial elections and getting rid of them. The flip side, is if we create a backstop and say it can only go so far and no farther, then we can work within that confine to say, let's have judicial elections. There are lots of good things about them, but and we know it can't get any worse than this. I mean, I'd be curious.
Well, you'd need a standard, and there's none proposed in this case. I mean, a genuine standard that you could rely upon. I suppose that's a big problem. Another one is, I'm not in this for judicial elections or judicial appointments. I mean, the question is, what in fact is going on in this case? And I think I'm unaware of some of the facts that Justice Neely mentioned. Maybe they're somewhere in the record. Maybe there's something he got because he's in West Virginia. But the problem is, it seems to me these highly factual matters ought not be resolved at the Supreme Court level. These highly factual matters ought to be resolved at the state level. The state Supreme Court can set up a commission, or the state, there's a Judicial Inquiry Commission, or they can send it back for some additional work by the trial court. It seems to me that that's a much more appropriate place for it to be resolved.
Would you favor, I mean, maybe you can address this, would you favor a process in which state Supreme Courts did have a means for reviewing disqualification decisions of isolated judges. I gather.
Oh yeah. No, it struck me as peculiar to hear that that most other states apparently don't do that. Yeah, I'm all in favor of that. I'm trying to remember Professor Frost. And it wasn't you. I just thought of it when that I do think there is a duty on judges to decide cases. And I think it has to be that way. And when Mr. Blankenship said, well, or maybe it was Professor Frost, said that there was this diminishing confidence, and therefore, I think the principal reason for the presumption is so that you can get cases done. If we're going to, any decent lawyer can come up with 36 reasons why a judge ought to recuse. I remember early on, someone asked me, the attorney said I should recuse because he had talked to his partner and his partner was thinking about suing me. And therefore, I never knew either one of them or any basis upon which any suit might be brought, and he didn't enlighten us with that. But he says, all right, I think it creates an appearance of impropriety that you would decide this case when my partner is thinking about suing you. Well, now, that one's absurd today. Maybe 20 years from now, if we go down this route, it won't be absurd. But if we're going to, unless we believe in a system where the parties are allowed to choose their judges, and I think that would be disastrous for our system of justice, then we need a presumption that a judge is not biased. And it has to be something extraordinary to get it above that. It could be that there's that extraordinary stuff in this case. I have problems saying, oh, yes, it clearly is. I wasn't privy to what everything was going on in West Virginia. But that's something that could be decided better in West Virginia than in Washington, D.C.
Is your concern with the standard that you have to disqualify if your impartiality might reasonably be questioned, or are you saying that that's an okay standard, it just needs to be a very high one? In other words, that's the general disqualification.
Well, I think that would be in the nature of the appearance of impropriety standard.
Yeah, I think so. It's in play in almost every state.
And I see that as there's no reason that can't be a state standard, since it is a state standard, and states ought to be applying that standard, but applying that standard reasonably. It's not that if I get you on a poll and say, if you knew this about Justice so and so, would you think he was likely to be fair? That's not the standard.
Yeah. Professor Frost, Justice C just talked a little bit about the gamesmanship that can go on with this. If you get the result you would hope for in this case, what would stop someone, the Blankenships of the world, from going back to West Virginia and essentially giving $1 million next time to McGraw, the McGraws of the world, so that when McGraw comes up, you can disqualify him simply because, I'm sorry, I gave you money. In other words, won't this just breed a new cycle of gamesmanship that is counterproductive?
Yes, and I think, Justice C, I understand your point. You do not want to create collateral litigation, satellite litigation on issues that do not go to the merits, that allow for delay in what is already a justice system that is too slow in lots of cases. I have sympathy for that. It's funny, as you were speaking, though, especially if you do embrace and agree with the state statutory standard, right? Not a due process standard. For the state, which is, could the impartiality be reasonably be questioned?
No, wait. I was talking about appearance of impropriety.
Whatever the standard is on the state level. Yeah. What's really too bad here is you don't want the Supreme Court stepping in. I don't either, the U.S. Supreme Court. Yeah. And I don't think, frankly, the state standards are perfectly clear and have bright-line tests either. Right. I think they work when they work through a commission system, such as I guess your state had. Or if they work through a system maybe of peremptory challenges, where one judge, there's a one-time recusal standard where you can ask a judge to recuse. The judge will step aside immediately, and that's it. You don't have another option. You can't do it again. You can't file such a motion again. Many states have that for their trial courts, and I think it works pretty well because it doesn't catch everybody up in this collateral.
However,
litigation.
if you make that a requirement, I'm not from Rhode Island or Connecticut, and you will have large geographic districts with one judge. And if that judge has to step aside, then you've got to reorganize your judiciary in some way or another to handle that. And I think states ought to be allowed to make those decisions on the balance of what they think is best for their system. And it ought to be what's best for the people, not just what's most convenient for a judge. Because I agree. I mean, there were cases I begged for reasons to recuse, but I didn't get it.
Just to go back to your original question, I think there are two reasons why you don't have to worry terribly much that would have to be the scenario that if you get gaming, somebody's spending $1 million to get a justice off a case. Number one, if the threshold is that high, then the likelihood of really spending $1 million, it's not trivial. It's not going to happen, routinely. That's a big investment if it is indeed a high threshold. Number two, the people who have worked on these proposals have looked at just that problem because it would be a risk on its own and suggested a waiver rule where in such a case where you're the opposing counsel and you think somebody has spent money to get essentially the justice you like off your case, you can just simply waive disqualification in that case. And that's designed to deal with that risk of gaming the system.
Why can't the party himself make it, though? I'm afraid you'll bend over backwards to make it look like you're fair, and therefore you'll vote against me. I mean, that's frequently the argument in recusal cases.
I think that the Supreme Court would do us all a favor to simply reverse this case without a lot of discussion on the grounds that, because $3 million is not the issue. There are conceivably bundlers. If you take a trial lawyer in a state that has a really well-organized trial bar, and he goes out and you say you have a $1,000 campaign limit. He goes out and he gets 500 trial lawyers from around the country, not just in state X, to contribute to a particular judge's campaign, and he comes in with 500 separate checks to the judge in one call. That would be grounds for disqualification as well. I mean, any amount of money that substantially deviates from the norm of individual contributions. But not a lot of discussion about the Supreme Court. Everybody in this room is probably too young to remember the civil rights cases or the civil rights trespass cases. But back in the 60s, the Supreme Court reversed a lot of state trespass cases involving civil rights leaders, freedom riders, blacks, right? Just pop, reversed, remanded, not a lot of discussion. We don't like this. And of course, that was back in the days when you had good, God-fearing Democrats left over from the Roosevelt administration on the court. I suppose led by Earl Warren. But there's a tradition of doing that, and I think that that's a good tradition for the Supreme Court to follow in this case. Too much talk leads to this you call it satellite litigation, and you absolutely don't want that. On the other hand, the Supreme Court should use my owl at a mouse picnic rule, that contributions that are far in excess of the norm in that state, such that both plaintiff's bar and defense bar can't more or less equally bribe, in the Sir Francis Bacon's term, is about the standard that you want, I think.
Justice Neal, I want to push back a little in the sense that one of the cases that you complained about, and I share, is the Republican Party of Minnesota case. Right. In that case, the court basically did they didn't reach the result you wanted, but they did take the approach of saying, all we're going to do is reverse on the notion that you can't take positions on issues that come before you. We're not going to talk about commitments. We're not going to talk about promises. We're not going to talk about any of this else. And in the years following, there's just been an enormous deluge of satellite litigation. Why? In part because they offered no guidance. And so why isn't it going to be the case that if all they do is say reverse, that then everyone is going to gear up and start litigating like hell until we get more guidance from the Supreme Court?
That's not what I call satellite litigation. That's one-on-one litigation, somebody telling a judge that he can't do this, or an ethics committee saying that. They're just working it out. If you bring that case up in Lexis, right? I can't afford Westlaw. If you bring it up in Lexis, you get a great big red dot here, you see, to say that it has been distinguished in virtually every state case in which it has ever been raised. So it's but that's something that's being worked out. When I talk about satellite litigation, what I'm talking about is filing a petition in the Supreme Court, having the writ of error granted, or what's now called an appeal granted, and then having somebody want to have an evidentiary hearing and a decision as to whether Judge X and Judge Y should be disqualified. That's what I call ancillary or satellite litigation. This business is simply working out a bad case. In other words, creating a whole bunch of precedent, inviting the Supreme Court to look at this again. They haven't bitten so far, but eventually they will, and we hope we get rid of it. It has ruined, and we actually in some states, the judiciaries, we have actually thought that the agenda of the Supreme Court was to destroy elected judiciaries. That the real hidden agenda of the White case was to destroy elected judiciaries by inviting the kind of problem that's been raised in the Caperton case.
I would like to, at this point, I think we're running to the point. It would be good to turn it over to questions from the audience, and we have someone standing by with a microphone.
Hi, Elaine Middleman, and I guess Justice Neal can answer this, or whoever wants to. Number one, is Caperton related to former Governor Caperton? And number two, how has this affected the sitting justices on the West Virginia Supreme Court now?
I don't know that it has had any great effect. It certainly is an embarrassment to all of us, and all the people who have been involved in the thing. I don't know that it's a continuing issue. People wait to see how it's going to come down, but it's not a topic of urgent concern at lunch.
Except this lunch.
Yeah, except.
Lee Burston, the more you discuss this, I can see pitfalls and solutions and bad solutions anywhere you turn. So I was thinking, should there be a process for motion of a change of venue, actually based on failure to recuse? Let's get it out of the state of West Virginia and move it to another state, state of Rhode Island, and let that highest court, a comparable court, decide the case instead. I know that's a very dramatic change, but is that within the realm of possibility when you can't come up with any other workable solutions?
I think it would probably require constitutional amendments in the states, because I know on our court, we weren't allowed to hear cases that didn't meet certain criteria, and a case that's from outside and has no particular connection to the state, we couldn't hear.
Well, and of course it's possible for other judges to step in when a justice steps aside. In this very case in West Virginia, two justices recused, two more took over those positions on the court. Mm-hmm. So, I don't know that would be necessary.
And in special cases like in disciplinary matters, if a justice on a Supreme Court is subjected to discipline and there's some concern that fellow justices might not be able to impose discipline. In some jurisdictions, there are special courts created within the jurisdiction, but I think the problem is you can't, in a federal system, it's very it would be impossible to take it to another state when it's a state matter.
And one other alternative that's a little bit less dramatic than going to another state, in addition to having other judges help you out, would be you create some type of body within the state that acts as more of a permanent advisor, and you can decide whether you give them true enforcement rule or not. But I certainly remember, for example, just from my own time in the executive branch, when I had ethics questions, which happens quite often, there was somebody I could call who routinely dealt with these issues day after day. They were the experts. They could give me at least advisory guidance, and I think judicial education in this area is pretty important. But I think if a state wanted to be bolder about this and really get to solutions, they might even consider an ancillary group that dealt with this. And I would, if that ever happened, I would urge that not just include judges and lawyers, that should include some of the public whose interests are supposed to be represented here as well.
Well, in fact, can't judicial investigatory commissions do that now? As you can always ask, I think normally you can ask for an opinion as to whether you should recuse in this case or not.
In some states, you can create that. Yeah.
Malia Brink, one of the really interesting parts about the Caperton case is the disconnection between the messages that were actually used by the 527 and the supposed underlying motivation of the person who paid for it and organized it. I was wondering if you could talk about what a due process recusal standard might mean in very direct correlation to Minnesota and to the messages actually used. So under what circumstances, if there is a due process standard requiring recusal, would someone who went out and said, I will cooperate with the DA and worked, convict all criminals and be tough on crime, have a problem in criminal cases?
The worst example of that I've ever seen, and the reason was because I was an expert for the Lowen Group when they sued the United States under the NAFTA Treaty for a complete denial of justice in the courts of Mississippi. I actually went down to Mississippi and looked at the Mississippi judiciary. This is a nonpartisan Supreme Court. I think it's a 9-person court, either 7 or 9. Nonpartisan elections. Mississippi elections, I was imitating, actually, I've done that so many times, the Mississippi judges in their campaign, political campaign. They all talk only about criminal law, putting criminals under the jail, etc. It's and millions and millions of dollars are spent in Mississippi, and it is all the chemical companies along the Gulf and the big manufacturers. Mississippi is actually a major manufacturing state, particularly for, I think, heavy chemicals along the Gulf Coast. And the trial bar, Dickie Scuggs and his boys, all well organized, and they each had their champion, coming out on the field of battle. But the entire battle centered around the one thing that nobody actually gave a damn about, which was criminals. I mean, nobody cares about criminals, and so except the voters. And I think that I meant to say that this does create a terrible problem. And it's something that we should address, again, on the canons of ethics, because if indeed you use criminal law as a vehicle for electing people who are primarily concerned with tort law, when they get there, if they're adequately cynical, they actually fulfill their campaign promises. As it turns out, the case that the 527 was talking about that McGraw wrote was a terribly tragic case of a boy who had been abused from the time he was 7 or 8 or 9 years old in a rural, some utterly Dickensian squalor in a rural county, and then had himself at the age of 15 or 16, 14, he was 14, had abused another kid, you see. On a 3-2 decision, the Supreme Court decided to commend this child, instead of sending him off to prison, to commend him to the Archdiocese of Wheeling, which had a program for him where they were going to make him a janitor in a parochial school and give him sort of assisted living and some help. And it may have been the right decision, may have been the wrong decision, but it was certainly an honest, legitimate, well-thought-out decision. And this kid was not a pedophile. I mean, he was not, somebody my age is a pedophile, right? A kid who's 15 or 14 is hardly a pedophile for having, been involved with a 9-year-old or whatever it was. So this is a perfect example, though. I think that the judges on the Supreme Court, you asked me how this thing has somebody asked, how has this played out today, this whole thing. I think that this whole issue of campaigns using criminal law as a way of running other agendas is very worrisome in the state judiciaries, because it is denying the integrity of the criminal law. It's a very, very bad thing.
I mean, just to quickly add, there's been a number of empirical studies that show that in states with elected judges, people get sentenced to longer sentences and they get sentenced to death more frequently closer to the election period. So I think there's a huge problem. What's the response? The response is, I don't see how we can have elected judges and get fair sentences in criminal trials. But the Supreme Court will never do away with elected judges in this case. So
the other side of that is check the federal sentencing guidelines sometime.
You would comment on Laird v. Tatum and any other, my name's Estelle Rogers, any other Supreme Court opining in the past about recusal standards. In that case, as I recall, I do recall, it had to do with Chief Justice Rehnquist and then Justice Rehnquist, his prior involvement while at the Justice Department in an issue that came before the court. So there was no money involved, But again, it was a Supreme Court justice basically saying, I can be fair and you can't second guess me. And have there been other utterances from the Supreme Court along those lines?
Well, there was an 18-page one recently by Justice Scalia in the Cheney case, of course, where he explained his refusal to recuse. I don't know of others beyond those.
I think it gets to the broader point that it would be a confidence-building measure if the U.S. Supreme Court were to consider, in cases of possible recusal, having at least some of their peers weigh in on such cases.
I mean, part of the problem to me is that there really is this you can see these two trains colliding from a great distance away. One train really has to do with the core notion of the judicial role that's been in place since Sir Matthew Hale, for heaven's sake, which is, we live, eat, and breathe impartiality. It's the presumption of impartiality that we talk about. When a judge ascends the bench, they take an oath, and if they fail to live up to that oath, in other words, by either conceding that I'm biased in a given case or that I've created a perception of bias, given that codes of conduct say thou shalt not engage in appearances of impropriety, they have in some ways failed. Coming from the opposite direction on the same track is this notion that in the 21st century, judges are people too. We can powder, we can stick a wig on them, put them on a bench, powder it, and they're still people. They're still capable of bias, and increasingly we've made disqualification standards more rigorous. And what we're seeing I think, beginning in Laird versus Tatum, and then again in the Cheney case, and to some extent here, is judges honestly saying, I want to live up to my oath and be impartial, in a world in which the public is saying, we are increasingly skeptical of your ability to do that, not because we distrust judges, but because you're a human being and you're subject to the same biases that affect the rest of us. And that's, I think, the collision we're seeing in this case and in the problem generally.
I'm Victor Stone, and this question I think is mostly addressed to the comment made by Ms. Frost, but I think it was touched on by some of the others. Listening to both sides here, as with any legal case, I think there's no question there's a case to be made for each side depending on what facts you look at. So I'm very confused as to why, if this is a due process argument to the Supreme Court, anybody would be arguing substantive due process, which is what I hear going on. Is this fair? Is that not fair? I mean, I could make arguments on both sides. Originally, the juror system, as people may know, way back in England, you only pick people who knew the defendant. Now we only pick people who don't know the defendant. Well, if the jurors are not allowed to know the defendant, why should the judges? But leaving all that aside for a second, and I've been involved in cases where I've gotten judges disqualified and other cases where I wish they'd been disqualified. I see this as a procedural due process case, and I'm at a loss as to why none of the litigants, if they hasn't said to the Supreme Court, this is very much like what happens when somebody comes up here to one justice, for example, to ask for a stay of execution, and if the justice denies it, we can go back to the full court. Or for that matter, in the habeas area, when dealing with states, if the state procedure doesn't allow for a factual hearing to which a federal court has to give deference, but if there is no factual review by the state, then the federal district court can give its own factual hearing and isn't bound by any state findings. So why shouldn't the procedural due process argument have been, we don't care what kind of review a state gives, but if it gives no review, then federally the due process clause requires us to intervene. So if you're going to let just the single judge decide without anybody, either a commissioner or preferably, I think, the whole court taking a second look, then we have to step in. And that's the end of it. It's just a procedural due process, which I think they would have a strong chance of winning. And you suggest they're all afraid to say that to the court. And I'm at a loss to know why.
Because the justices of the Supreme Court of the United States also decide on their own whether to recuse themselves. Well, I think that would be a losing argument. I think Ted Olson knows what he's doing.
Is the implication of what you're saying that a justice who says it's fine for me to decide on my own would say, but not for you to decide on your own?
But the justice doesn't decide on his own when a bail question comes up.
Well, that may be, but this is a disqualification question, and on those, Justice Scalia decided the Cheney case, and Justice Rehnquist decided the the Laird case without any assistance and without any possibility of review. I guess it's a real politic point. In other words, I think all of us in this group assembled are of a mind that the best approach would be to create some. Maybe Justice Neely disagrees, but there would be some procedure in place to at least allow for a backstop when a justice declines to disqualify himself. But I think when the history of practice since the founding has been that individual justices are the final word on that, the idea that they would say, well, we've been committing a due process violation all along, is just a hard argument to make. That would be.
I think the politics of courts of last resort are sort of an impediment. You can have very intense political divisions and personality divisions. Courts can actually become violent. I remember that many of you have been, well, older folks have seen the D.C. Court of Appeals back in the 80s when you had Leventhal and McGowan and all these folks who believed that they had heads, about this size.
Really big.
Right, really big, right, and they were struggling with one another, but they didn't even discuss cases. They just went in and voted. I mean, they were so. It was such a contentious court. I think that you can have that also on state courts. In fact, the West Virginia Supreme Court had a few years of that. Not now, but in the early 2000s. And I think that if you have a system where the whole court can vote on a judge's recusal, you would then have strong factions disqualifying members of the weak faction. The bigger the court, the less the risk. I would think that you would have a very low risk of that on a 9-person court. But here's the other risk. The other risk is that if you have an eccentric justice, and there have been a lot of eccentric justices, I mean, not just, guys in clown costumes like me, but people like William O. Douglas, you could actually have those justices pushed off of cases by that process, and such that they couldn't dissent or do their things. So it might impede the level of real imagination. You agree with that?
Yeah. I agree with you too. Though I think a 9-member court, it would be very unlikely. A 5-member court, you'd have to worry about it a bit more. Yeah. But also, I mean, they have to understand too that factions can change, but they may not always understand that.
Penn Doyle with BNA. I just wanted to ask the simplistic reporter's question of, do you have predictions about what the Supreme Court is going to do with this case?
Decide it.
How?
They took it to conference 3 times before they let it in. You know that? I mean, everybody know that? This was obviously a true conundrum for the Supreme Court, because they apparently discussed it in 3 separate, whatever they call it, writ conferences, or cert conferences, maybe they call it. So it's got to be close.
The one thing I'll say is, based on things the court said in the White case, the Republican Party of Minnesota versus White, I wonder whether, if they do end up ruling in favor of petitioner, whether they will avoid setting a standard, as the petitioner seems to want, but plead with the states to start taking some action to police themselves. I mean, I think the U.S. Supreme Court agrees with you, Justice C., in that they want the states to police themselves, but to do a better job than they've been doing. And so I wonder if they will use this case to kind of give states that message.
Will they reverse or affirm?
I would say if they reverse, that would be the.
Of course, they could do it either way.
Either way, yeah.
I would agree with everything said, and for that reason, this may be one of those many cases that is a war for the soul of Justice Kennedy. And if you look at the briefs, I think I think both sides think that as well.
I actually would like to follow up on the last point. Regardless of what the Supreme Court does, do people on the panel agree or disagree that the states really do need to do something given the current climate? I heard some discussion early on that this would be a draconian change for courts, but then it seemed like most of you agreed that if you had some sort of review of a judge's decision, it wouldn't be that big a deal at all. So is this something where the time has really come for states to clean up their own houses?
I think it depends on the state. I think probably in most states it's not a problem. But there are key states in which there are serious battles going on, and as a result, these recusal motions are made in situations that may stretch it a little one way or another, or situations are such that it seems more appropriate to make it. Yeah, well, as I've said several times, I see no problem with having a review by the court. Although, as Justice Neely points out, there is that possibility of cutting a justice, an elected justice, out of deciding a case he was elected to decide. I mean, he's elected to decide all those cases in which he doesn't have a genuine requirement to recuse, and there'd be the danger of the majority cutting him out. But, if it's the majority, I suppose the case is going that way anyway, isn't it?
I mean, I would be even more emphatic that the time has come to step up on the part of states that are dealing with this problem, regardless of how this case is decided. And I would also suggest or even warn for courts whose, this is traditionally their rulemaking power, that if they don't step up, they could find legislatures who might be willing to step in. And nobody wants that. But if a court decides that it can be business as usual, even though the landscape of judicial elections has changed, they may find themselves no longer the final arbiter.
I'd go a little further still and suggest that, although this is the stuff of John Grisham novels, that the problem at the grassroots level, at the trial level, is there too in a limited sense, in the sense that the norm around the country is that judges decide their own disqualification motions. And these are smaller, less consequential cases unless you happen to be the person who thinks that the judge has a financial interest, a personal interest against you, and you find out first that the judge is the last, not the last word necessarily, but the first word on whether you get to, whether he gets to sit in his own case. And when that decision is made, most jurisdictions say that, yes, you can appeal it, but it's subject to an abuse of discretion standard of review, meaning that the appellate court will look very, very gently at whether the trial court, who has, in the mind of the litigant, a vested interest in voting against you, whether letting that go. And so I think that I'm not making a brief here for changing those rules wholesale by any means. But I think if we're looking at inquiring into disqualification practices, it really shouldn't be limited to the state Supreme Courts and those few high-profile cases that make all the headlines, but we ought to be looking at just the way judges do this in rank-and-file cases around the country.
Actually, in West Virginia, we have solved that problem. We have a very fine, expedited system for disqualifying a trial judge. And we have a superb judicial reorganization amendment that allows us to assign judges around the state. When I was Chief Justice, I would pass on about 6 recusal motions a week. The judge disqualified him. There was a motion to disqualify him. He either disqualified himself or he didn't. But regardless of what he decided, it came to me. And if he disqualified himself and I thought he was getting out of work, I said, no, you're not disqualified. Hear the case. If he didn't disqualify himself and there was a colorable a case made that he had represented somebody or something like that, I'd send it back for another judge to come in quickly and hold a recusal hearing. Yeah. And if it was obvious, I just said, you're disqualified, zap, and that was the end of it. So we have solved that. I mean, West Virginia gets a bad rap on this case. So I just want you to know that while those of us who run the system are totally dishonest, with regard to the people who work for us.
I think we have now sort of exhausted. I think I don't want to exhaust the patience of the audience, but it's now 1:30, and I would assume that the panelists would be happy to chat one-on-one with folks who may come up afterward. Thank you for your indulgence.